Okay, everyone, we're ready to proceed. All right. Ms. Anthony, you're ready to go. And just to remind you, each of you have gotten 20 minutes to make the argument. And how much time do you wish to reserve for rebuttal? We allot up to 5 minutes, Ms. Anthony.
5 minutes, Your Honor.
Very good. And whenever you're ready, let's proceed.
Good afternoon. May it please the court. Stephanie Anthony on behalf of the appellant, Savannah Capital LLC, derivatively on behalf of DeVille Corporation. This is an appeal of a summary judgment in favor of the appellee, Patisi Dowell and Markowitz and Dealey Patisi individually. This was entered without the appellant having been able to conduct any discovery. Specifically, Savannah Capital was attempting to take the deposition of Lee Patisi, but was prevented from doing so by the lower court when it entered a protective order, which is also part of this appeal. Savannah Capital contends that the trial court erred in entering this protective order absent a showing of good cause for the same.
And can I interrupt you, Ms. Anthony? I want to make sure I understand at least the procedural aspect. In this case, you were very clear, at least you made it clear that you are proceeding, Savannah Capital brought this claim that's currently on appeal. Individually, is it individually and on behalf of DeVille Corporation? That means it's proceeding individually as well as on a derivative claim, correct?
Your Honor, it does state that in the caption, but I believe at the prior hearing, we conceded that we were only proceeding derivatively.
Okay, so that's all I just want to clarify. So you are proceeding derivative in this current action, and that's all I just want to make sure. Go ahead, ma'am.
Yes. So as I was stating, we believe that the entry of the protective order was entered in error absent a showing of good cause. And then the third issue in this appeal relates to the trial court's order denying Savannah Capital's motion to disqualify the presiding judge.
Let's focus more on your very first couple of ones and just help me out so I could, at least I could understand. You're taking the position, at least your verified complaint in this matter. You want to proceed, it's a legal malpractice case against the attorney, saying that either because of whatever relationship that he had with your company, that he failed to file the appropriate claim in the bankruptcy court. That's in a nutshell. Am I saying this saying correctly?
Yes, Your Honor. Okay.
And so the allegations that you set forth in your verified complaint, you give examples that even though you have to show at least on the four corners of the complaint that you're bringing a claim that there's some sort of relationship between you and the attorney. So you put in there that in the past that this specific attorney has done work for your corporate client, and you've indicated, at least based on that, it gives you, at least this is what you're seeking, that based on this past representation, that you're taking the position that he should have at least protected your interests in the bankruptcy court, and that's why you're proceeding with this verified complaint to get damages against him. Am I saying that correctly?
Somewhat, Your Honor. Not only did he have a relationship with DeVille previously, but they did represent DeVille in the bankruptcy case and in an adversary proceeding. So the appellees try to construe it as a limited representation, and we would disagree that there was any limitedness to their representation in the bankruptcy case. And in addition, we support that by showing that there were other actions where, in fact, this law firm represented DeVille, quite regularly.
So you're trying, at least in this lawsuit, to show that this is what your client believed, and therefore you're seeking redress against the attorney for his failure to basically protect your client's interest. And so this is what you're proceeding, at least based on the verified complaint, which leads me to which really leads me to this question. When the summary judgment was filed in this case, and I know that there was prior to the summary judgment, and I think the other side filed a motion for protective order. You wanted to take the deposition of the attorney, and then the motion protective order, there was a motion, there was a hearing, and the court basically ruled you cannot. We don't have the benefit of the transcript of that protective order, but in a nutshell, I guess we just have to assume the judge said, sorry, no go, you're not entitled to take that deposition. So do we need to have the transcript of that protective order to determine as to whether or not the propriety in this case for the court disallowing you to take his deposition?
Your Honor, I don't think so. I mean, the case law is clear that, summary judgment entered prior to a party being able to take discovery of a material witness, and complete discovery in general would be premature. We had filed also a motion to abate the summary judgment consideration, to allow us time to take the appropriate discovery. That motion to abate was denied the same time as the motion for protective order was considered and granted. There's no sworn proof or evidence supporting the summary judgment motion that was filed. We believe that's another grounds for this court reversing the summary judgment order. I know that maybe didn't answer your question.
Because I'm trying to find out, because one of the things that's presented before us, you wanted to take the deposition of Ms. Patici, and there was a motion protective order, and there must have been a hearing. I don't know what was discussed at the hearing, what were any concession, if any, were made, but there's a ruling that you're not allowed to take that deposition. And then next thing we see is the summary judgment. And then here we are on appeal, where the court basically indicated that there's no issue of any material fact, and therefore you lose. So this is what I'm trying to ascertain.
I understand. So the assertions were set forth in the moving papers. So you do have those as part of the record. And then at the hearing on summary judgment, again, I told the court why we needed the deposition of Leif Patici, and that was to get to the issue of what his scope was in the representation of DeVille in the bankruptcy court.
Because you're, at least based on the allegation that you set forth in the complaint, that there has been prior representation in the past, all you're trying to do is to take his deposition to find out, hey, did you represent us? What is it, like he used the word, the scope of representation. He could simply say, nope, never did that, then it'll be end of story. But you've never gotten that chance, at least, to take his deposition, correct?
We never got that chance. And in fact, there was no affidavit of Mr. Patici or his law firm that said that in support of summary judgment. Obviously, if he had filed an affidavit, I would have wanted to cross-examine him on that. So I don't know why, but there was no sworn evidence in support of the summary judgment. And their contention is basically that because of what happened in the bankruptcy court, there's no issues of fact and summary judgment should be granted.
But in this, we're dealing with a different lawsuit, right? We're dealing with a derivative action that you're bringing forward. So we're talking about apples and oranges. We're not talking about the same thing. So that's what I'm trying to understand. Why did the court came to the conclusion that you're not entitled to take the position of a party defendant in this case?
Your Honor, I agree it is apples and oranges, and I didn't understand the rulings either. believe there was a court reporter that was supposed to be at that hearing and didn't show up, and I was not happy about that either, but the hearing must go on, so to say. So I'm stuck with the record that we have, and clearly as you pointed out, the issues in the bankruptcy case are totally different than what we were attempting to have tried in this action, and I merely wanted to get to the scope of what Mr. Patisi was retained and his law firm were retained to do on behalf of DeVille, given their representation in the actual bankruptcy case and the adversary proceeding, and we were not entitled to do that discovery. We believe that was an error. As I stated, there was no evidence. They just merely pointed to the records and the bankruptcy proceedings, and then there was an appeal of the bankruptcy court order. But again, that there was no finding as to what the appellee's representation was or the scope, because that just was not at issue in the other case. So that should not have been enough for the court to say, I'm on the same page as the bankruptcy court. I agree with the bankruptcy court. Well, maybe the court agreed with the bankruptcy court, but the issues were totally different. So that doesn't.
And this case is up on appeal on the posture that summary judgment was granted. So we have to look at the whole record before us, including, and this complaint was a verified complaint. It was signed, and basically based on the allegations that was sworn to, you did allege that there appears to have been some representation in the past. And so you're making a claim that that should have been done. And so was there, and maybe that's more, Mr. James, I think that's more, be prepared to answer that, because that's one of the concerns. Was there anything in the summary judgment? Did they file an affidavit saying absolutely not, there's no representation whatsoever? Absolutely not. They just simply relied on the materials that are in the bankruptcy court. Is that correct?
That is correct, Your Honor. And we filed a notice of a pending action that was occurring, simultaneously. We call it the records action in our record, where the appellee firm was representing DeVille. So, yeah.
And you lay that out, and it's there that was, so there at least there's a colorable thing that there may be something there. And basically what you're telling us, you wanted to pursue that, you wanted to take the deposition of this party defendant just to determine, and you were foreclosed from doing that.
Yes, Your Honor.
All right.
Okay. And then, so as I was stating, the appellee's contentions in their summary judgment motion was just that somehow the bankruptcy filings conclusively established that the appellee's representation of DeVille was limited, and it did not include the matters that were at issue in our underlying complaint. They also go on to state that it would be ludicrous to assert that a president of a corporation would be in the position to retain an attorney to sue themselves. So the appellees represented not only DeVille, but they represented Tom Martino in his bankruptcy case. So I believe that actually supports our position that there was a breach of the fiduciary duty and malpractice. Your duty when you represent a corporation is first and foremost to the corporation. You can't represent the corporation and the principal or one of the shareholders unless the lawyer is convinced that the differing interests are not present. And we have cited case law to that effect in our briefs, the Brenner versus Ruffner case, and And one case that I would note is the Williams versus Stanford case, which I don't believe was in our papers. It's a first DCA case that states that law firms and lawyers breach their duties to their corporate clients when they undertake simultaneous representation of a large shareholder or its principal, and the law firm serve the interests of that principal at the expense of the corporation, and any resulting conflict cannot be waived by that principal. And that's what I think we have here, but we can't even get to the scope.
I just want to tell you, you're about to go into your rebuttal time. So do you wish to go forward, or do you want to save the rest for rebuttal?
I will save the rest for rebuttal. Thank you.
Thank you, ma'am. All right. Again, I'm going to have you mute your microphone, and then Mr. James. All right, Mr. James, I'll tell you what I'm concerned with. And please, I just want to be able to get right into the heart of it. We have a verified complaint. It's a derivative complaint, okay? Derivative allegation saying that here's a party defendant. Here's someone failed to do what we're outlining in the complaint. And in the past, there's been some representation in this. And so we have that, and it's a verified complaint. Then fast forward, want to be able to schedule the deposition of a party defendant, just to inquire as to the scope of the representation. Motion protective order filed, court for whatever reason grants that. And then the argument at the summary judgment hearing is like, hey, you look at all this record, there's absolutely no way that he represented them. Isn't that go? Don't they need to take the deposition in order to make that determination? Isn't there a factual determination to be seen versus as a matter of law, we don't represent the corporation? Help me out, Mr. James.
Certainly, Judge Kuzam, and I appreciate the opportunity to answer that, because I know that would be the first question you'd ask me.
Okay.
And I do want to kind of clarify the kind of factual premises that we're working under right now. In the verified complaint, there are actually 3 different examples of situations where Mr. Patisi and his firm represented either Martino or DeVille. And those 3 examples that were cited, those are the only ones that are in the verified complaint, all revolve around this same time frame. This doesn't go back, we're not talking about 20 years going back. We're talking about in Mr. Martino's bankruptcy case, in the adversary proceeding, and then in the records action. So all the things that we're talking about in this case that are alleged to be problematic, that time frame is what we're talking about as far as the representation of Mr.
Well, why don't we start right here? You do defense work. When's the last time you got a motion for summary judgment granted and you didn't take the plaintiff's deposition?
In this case?
Never. Okay.
This case, Your Honor.
So here we are. Mr. Patici is being sued. He is a party. He is a named party being sued for professional malpractice. All your client did was file bankruptcy records, and we don't want to talk about bankruptcy. That's why we're judges over here in state court. So don't give the minutia, okay? Mr. Patici was there in the bankruptcy court representing Mr. Martino in April of 2015. You can squabble all about who he exactly represented, but that's still a question of fact, because you did not file one piece of evidence from Mr. Patici at all. The summary judgment rule 1.510 says only after pleadings, depositions, answers to interrogatories, and admissions on file. We don't have anything in this case, and you got summary judgment because Frank Gassler said it's ludicrous for Tom Martino to hire Lee Patici to sue himself. That's not an argument. That's not evidence. Summary judgment can only be granted on admissible evidence. What? And you've argued that, okay, Lee's going to be annoyed. He's going to be embarrassed. He's going to be oppressed. He's going to have an undue burden being deposed as a defendant when he can sit here and say, DeVille hired me in May 2015. That's why I filed my NOA. That's it, period, end of story. He does not have to disclose confidential attorney-client privilege material. So tell me, because there's a whole spate of cases here that say a protective order that excludes the deposition of a party, you cannot enter summary judgment. It's premature. You can't do it. So you've gutted their case. I mean, they have a right of due process to take the deposition of an opposing party. This isn't just some sort of eyewitness, some half-blind 80-year-old person in the neighborhood that saw something. This is a defendant party. And Judge Cook granted your motion without any findings whatsoever. None. And it's a high standard of good cause to grant a protective order to deny a party's deposition.
And Your Honor, that is what Judge Cook determined after seeing the issues in the complaint, the discrete issues raised in the complaint.
Yeah, but the only thing that you filed in your protective order, you did not file an affidavit. You said this allegation, which is not evidence. You said that the motion for summary judgment issues will not be affected by the testimony of Mr. Petici. That's the only thing you said in your protective order. Nothing else. That's an attorney's opinion. And then in your motion for summary judgment, you say it again. It'd be ludicrous for Mr. Martino to hire Lee to sue himself.
Right, Your Honor, and that's because we had the benefit of such an extensive litigational history.
So what?
That obviated the need for this type of deposition and discovery.
So what? I don't care. You didn't take Lee Petici's deposition and he didn't say yes or no. You tell me if Judge Cook had all the evidence before her to determine that there's absolutely no genuine issue of material fact as to whether Lee Petici represented DeVille during the time for proof of claims. Can you honestly say that?
Your Honor, I believe she had the information that she needed to make the reasonable decision that she made. And that could have been done at the hearing, which again was not provided to the court. But
we don't need it if there's error on the face. We have a judge saying you cannot take a party's deposition. And you just told me you've never gotten a summary judgment where you didn't take the plaintiff's deposition. You just told me that.
No, that doesn't mean that it can't happen. And it happened in this case because
cite a case in a legal malpractice case where the defense got a summary judgment where the defendant lawyer was never deposed.
I can't cite that case to you, Your Honor.
Thank you.
You can't. But I do cite cases that show that it is a discretionary issue, and it is a situation where the judge has to look at the specific situation, the allegations and the assertions about what was actually done wrong by the defendant attorney, and then make the determination as to what discovery is necessary or is not necessary in order to reach a summary judgment on that discrete issue.
Do you honestly think that telling the judge that Lee Petici's deposition testimony will not affect the issues on the motion for summary judgment is an adequate argument in which to grant a protective order?
Well, I agree, that's argument, but she had other information in front of her. She had information about the nature of the bankruptcy proceedings. She knew that Mr. Martino, who would have had to authorize any of this action, was the president of DeVille. And in order for DeVille to have had to have taken any of these steps and authorized its attorney or to have hired Mr. Petici's firm to take any of these steps, to file a proof of claim, to engage in the non-dischargeability action, the president of DeVille would have had to engage Mr. Petici to do that against the president of DeVille.
Yeah, but how do we know that Tom Martino said, hey, Lee, by the way, don't tell DeVille right now. I don't want you to represent DeVille, just me right now. No, I don't want you taking care of DeVille right now. How do we know? We just don't. How do we know that Tom Martino was running the show and telling him what not to do? Tom Martino is DeVille. He's responsible for it.
That's why derivative actions are in place in order to avoid these kinds of situations.
Only if the DeVille shareholders know about it.
Well, and notice is an important thing in this case because in the bankruptcy proceeding, Savannah Capital which could have at any time brought a derivative action against Mr. Martino on behalf of DeVille, had ample notice of its ability to do so.
Yeah, but
Judge-
they also
Judge-
told I can't remember the name of the bankruptcy judge, May, I think.
Judge May, yes.
But they also told Judge May, Savannah's attorney said, you know what? We thought this was a legitimate loan. They didn't have any evidence to the contrary.
Your Honor, they
Because
had.
we don't know Petiti's representation of Martino.
Right, but Savannah Capital knew enough to file its own claim, its own proof of claim, and knew enough to file its own adversary proceeding. And so therefore, after it was told that, hey, there's a standing issue here, there's a derivative action to be brought here, and they decided not to do that for whatever reason for many, many months. And that is what the issue is in this case. That's what breaks the chain of causation. Regardless of representation, regardless of the scope of anything that Mr. Petici may or may not have been engaged to do, we still have a causation problem.
Well, if it's that easy, Mr. James, where's the oppression and undue burden and annoyance for Lee Petici to sit down and raise his right hand and swear to tell the truth?
Because in a situation like this, where the causation argument is so set in stone based on the documents that we have.
You can't say easy again, can you?
That any having any discovery done is maybe not a lot of oppression, but some oppression.
Oh,
some
come
burden,
on.
some burden. Some burden on.
Come on. They're not looking
They
into
have to do
Lee's. This is not. They're not going to work product.
And that's what Judge Cook made her determination on. She saw the issues in the case. She knew what they were going to be, and she realized that nothing that Mr. Petici said was or was not going to have any bearing on the actual issues in that particular discrete question. And that's why she did what she did.
You would have to have a crystal ball to be able to determine that.
Well, Your Honor, that was Judge Cook's ruling, and she had the information that she needed, and we submit that it was not an abuse of discretion for her to do that.
And if I may, Mr. James, and I need to interrupt you
Sure.
because you've mentioned words like discretion, abuse of discretion, but we are dealing right now with an appeal based on a granting of a final summary judgment.
Mhm.
And the case law is very clear. If there's any issue of material fact, and the standard is like any little thing, we are seeing, and we have all the documents that was before Judge Cook. So our court could look at everything that was presented there. We also have this verified complaint, and the verified complaint under oath, it does indicate that there's some issue with respect to representation. And so that's there. And everything that you're saying right now is argument about why it should not have happened, why summary judgment was granted, why abuse of discretion. Well, that's not the standard. The question before us says they have the right to proceed with discovery and to take a party defendant's deposition. And the deposition, if they would have taken the deposition and Mr. Petici said, no, we never had that. We're not in privity. We've never had that. Fine, period. Then Judge could proceed with her granting the summary judgment. Right now, the posture that it's in, based on all the records that you're relying on, there is a question of fact as to the scope of representation. So that's what I'm struggling with, Mr. James.
Your Honor, we're also forgetting about the causation argument that breaks the chain. So this court can certainly determine that the underlying ruling can be affirmed, even if this court finds there's some issue of fact on the scope of representation. We still have the main issue that was not the proximate cause of Savannah Capital's individual.
And if I could understand, you're saying that because they waited and because they didn't do it after the fact, that's why, there's no causation. But I think that defeats the argument where if they were under the impression that this attorney was partially representing their interest, and they were being lulled in the sense of, oh, we're going to rely on him to protect our interests way before the deadline, why don't they get the chance to at least question him, to develop that, to make a determination whether it's accurate or not? Because causation is a factual question. Causation, you need to have the facts in order to come to the conclusion that, hey, there's no causation in this case. So you're making that argument, but we are in a summary judgment posture. And so that's where the problem that I see the problem is.
And let me address that, Your Honor. And I understand causation is typically a question of fact, but
Yes.
there is case law, and we've cited that in our briefs, that it can be decided on a question of law in the right circumstance. And I think the documents that were before the court allowed her to do that. Now, as far as the timeframes we're talking about, we're not talking about a year after the fact. Savannah Capital finds out that we were duped. We thought that Mr. Patisi was representing DeVille all along, and we thought that he was going to take care of everything. Now, this all happened concurrently. This happened when Savannah Capital filed its own proof of claim after the deadline ran for other proofs of claim to be filed in the bankruptcy of Mr. Martino, and DeVille had not done that. That is when Mr. Patisi first noticed his appearance for Mr. Martino and DeVille. They knew at that point, and this is maybe a month later. We're not talking about years. This isn't that far after the fact. And they knew that Mr. Patisi was kind of involved in these situations, such that if Savannah Capital had an issue with Mr. Patisi not doing what they thought that he should have been doing for DeVille, Savannah Capital at the very same time had the right to not only file a proof of claim on behalf of DeVille, the bankruptcy rules allow that, and they did not do that. They filed one for themselves, so they absolutely knew that there was a claim. But then they also had the opportunity and plenty of notice, and this is raised by Judge May, this is raised in the answer and defenses in the bankruptcy court, that no, a direct action was not the right way to go here. The only way that Savannah Capital could seek any redress for DeVille was by filing a derivative action as an adversary proceeding in the bankruptcy court. And
there's no doubt about that.
And they could have done that. And the reason.
Hold on a second. Wait a second.
Sure.
Can you hear me?
Yes.
Wait a second. I agree with you there. But that's all bankruptcy issues for standing and jurisdiction. But what you have in the record, of course, you didn't file any evidence whatsoever, but what you do have in the record is in April of 2015, Lee Patici is sitting there with an appearance, and he is listed as a lawyer with David Steen representing Tom Martino. And part of the issue is whether Tom Martino stole $1 million or it was a loan. He's there with the president of DeVille, a 50% owner of DeVille. Savannah, your client owns the other part of DeVille. They're all related. They're all interrelated. Doesn't matter. Lee Patici's sitting in there. He's listed as a lawyer making an appearance. He actually spoke during those hearings. This is April 2015. Now, you're talking about everything that you say may be true, but that's only assuming if DeVille retained Lee Patici after the proof of claim deadline. But we don't know that because we don't know who retained him in April of 2015 and why, and we don't know why he filed his notice of appearance on May 18th, 2015, as opposed to earlier than that, during the proof of claim deadline. We as neutral judges here must look at the whole case. So what we see is we're not attributing anything to anybody. But Mr. Patici is involved in Tom Martino's bankruptcy, and he is the person who started all of this stuff with either stealing money or a legitimate loan. And Lee Patici is representing him, and Tom runs DeVille. Okay? I cannot understand for the life of me why you would prohibit the deposition of an attorney who is a party who has acted under these circumstances.
And Your Honor, we did so because we felt so strongly about the fact that Savannah had its opportunity to do that previously, and that the summary judgment did not rely on that. And Judge Cook agreed, and she saw
but the bankruptcy records are not evidence. Summary judgment must be granted on evidence. You submitted none. Attorney's arguments, not evidence. There was no testimony in the bankruptcy court except for Mr. Martino.
We filed a request for judicial notice of public documents, and those documents and the orders by Judge May and the 24-page detailed order by Judge Covington set forth everything that we needed for summary judgment. And when Judge Cook saw those things, and she knew that was the bulk of the evidence, she realized that discovery was not needed to resolve the specific issues that were involved in this motion for summary judgment. And that's what she based her argument on. And that was not an abuse of discretion, Your Honor. And
Mr. James, you have about a minute left if you want to wrap it up, sir.
Okay. Yes, Your Honor. And I appreciate the time. And I do. I just want to submit that this whole situation could have been addressed back in 2015. In 2015, Savannah Capital had the opportunity to obviate the need for any of these proceedings. They had plenty of notice. They knew that their standing was an issue, and they were basically told to file a derivative action, and for some reason did not do so. And so we're here because of that. And we believe that Judge Cook's ruling should all be affirmed in full. Thank you.
Thank you, Mr. James. All right. And Ms. Anthony, I believe you, I'm looking at my notes. I think you had about 3 minutes, I think 4 minutes for rebuttal. Go ahead, ma'am.
Thank you, Your Honors. Just to respond to the main thing that I think I'm hearing from Mr. James' position is that somehow the appellees are absolved from any wrongdoing because Savannah should have done something differently in the bankruptcy case. However, I don't think that case law would support that. You cannot avoid liability by blaming co-counsel for legal errors in the case. And in the bankruptcy case, the appellees were representing DeVille. Savannah was representing itself and proceeding individually. Mr. Patisi and his firm were representing DeVille and Mr. Martino. They cannot point to any case law that would show that Savannah has some duty to pursue claims derivatively just to escape any liability for a breach of fiduciary duty as we're asserting here. I believe we cited in our paper some case law on no duty to mitigate. The Green versus Leasing Associates was one that we cited. And Your Honor, I think our papers set forth everything that I may have missed today. And we would certainly rest on anything I missed in the briefs. But I did want to point to, in the motion for protective order, as I stated, they do in fact state that in their paragraph 7, that plaintiffs will likely argue that they need Mr. Patisi's testimony to address the motion for summary judgment. Then goes on to say, as explained above, however, the issues raised therein are based solely on court documents, which are self-explanatory, and therefore Mr. Patisi's testimony is not likely to produce a genuine issue of fact. And then they cite the Colby versus Ellis case for the proposition that when a record becomes clear enough to disclose that further discovery is not needed to develop significant aspects of the case, and such discovery is not likely to produce a genuine issue of material fact, discovery should be ended. That's not the case here. We needed to take Mr. Patisi's deposition, and I stated several times we needed to get into the scope of the issue, and Judge Cook was not convinced. We also attempted to point to some amended bylaws.
Ms. Anthony, if I may, you're actually right up to the end of your rebuttal, ma'am. So, all right. I just want to thank you both, really well argued. And I know we peppered you, Mr. James, and but thank you both for really well argued case. So at this time, we're going to go ahead and sign off. Thank you both.
Thank you.
And have a great day, everyone. Bye-bye.
Thank you.
Bye-bye.